So the House Supreme Court has upheld a law that allows prison officials to extend the sentences of certain inmates based on their behavior behind bars. Christopher Hacker and Danan Simmons Jr. challenged the law, saying it infringes on the state constitution's separation of powers between the judicial and executive branches, which allows prison officials to act as prosecutors, judges, and juries in determining extended sentences. And the 2019 law, known as the Reagan Tokes Act, gives the Ohio Department of Rehabilitation and Correction the authority to request the parole board to keep felony offenders in prison beyond the minimum of their sentence range. Joining us now is Ohio attorney Fanon A. Rucker to explain this. Attorney Rucker, glad to have you on the show. So let's understand this. In fact, there's a similar law in Texas. I know a pastor, former pastor, Terry Hornbuckle, who was convicted of rape, was sentenced to prison, sentence was up. Based upon his actions, based upon him never admitting any remorse, he was literally sent to a psychiatric facility where he still remains because they felt he was still a danger. So what's still strange about this is, so how can you have a court of law that makes a determination, but then there's an arbitrary decision made by the prison system to still keep somebody in prison?
So, Roland, first of all, let me offer, I am so humbled and grateful to be able to join you again, and certainly talking about important legal issues that impact us all broadly. Let me just give some background. As you said, this was passed in 2019 under the guises of criminal justice reform. And what this law said is that for certain first and second degree felonies, which are the most, the highest degree of felonies in Ohio, judges are required now not to give a certain sentence, but have to give an indefinite sentence. They have to give a minimum, and they have to extend that to have a maximum. The law says there's a presumption that folks are going to get out on that minimum. But as you pointed out, and this is where it becomes an issue, the Ohio Department of Rehabilitation and Correction has the ability to say, we don't think that this person is ready to go out into society, so we're going to extend the sentence. And they can extend the sentence from that minimum up to the maximum, which the statute also prescribed is 50% of the minimum. So if you get a 10-year sentence, now you got 10 to 15. And so even though you could get out at 10.
Okay, I'm confused here. So I'm used to, I sentence you to 20 years in prison. And then based upon behavior, you might get time off for good behavior. And then you could get out earlier if you're paroled. So you're saying that when somebody is now sentenced in Ohio, there's no precise sentence. It's 8 to 12, and then it's up to the prison to decide whether you get out 8, 9, 10, 11, or 12?
Which is the reason for the challenge. Let me just offer, I was a prosecutor. I was a judge for most of my career before I retired. I spent 13 years on the bench. And as judges, we appreciate our independence and the ability to enforce the sentences that we impose. And why this is a problem is because you got the judicial branch, which says we're going to make the decisions about the person's guilt or innocence, and then we're going to decide the appropriate punishments. And then the executive branch, which is not supposed to be making those decisions, making the decision that even though you sentence them, we're going to allow that sentence to be expanded by our rules and by our determination. And there's no specific parameters about how those determinations are made. That's a problem.
So again, I guess what's strange to me is how then does the prison come to that conclusion? How arbitrary is it? Is there a defined rule? Is there a, like what? How does that even happen?
Yeah, it says that in the law, it says that the DRC, the Department of Rehabilitation and Corrections, may rebut the presumption of the minimum sentence if, and they have about 4 factors, if the person has had an infraction during their prison term, which suggests that they're not ready to go back out in society, if at the time of their minimum sentence they're classified as a certain level of offender, or if they decided. And then there's a little 3-word, at a hearing. It gives no specifics about what kind of hearing, who's representing, who's represented, whether the offender himself or herself actually has the opportunity to present at this hearing. I mean, it gives no parameters, which makes it really an arbitrary, one-sided decision made by an entity that has at its core keeping folks locked up to say, we're going to keep you for longer. And that's where there's a problem with this decision and, of course, with the law.
Wow. Question from my panel. Robert, you first.
So with this, what are some efforts that can be made to try to change this? Now that you've gone through the judicial system, does it have to be a legislative solution? And what exactly do you think would be the necessary from the community to push through a legislative solution?
So, yes, a good question. You're correct. This was a legislative issue. The court has said, it's okay, it's constitutional. So now the only fix to it can be back through the legislature. And what can the legislature do? They can remove that arbitrary decision-making authority by DRC. Will they? Not likely. Why? Because Ohio, at this time, is a state that is primarily controlled by the same entities that passed this law in 2019. And so for them to reverse themselves, where they have a supermajority, is extremely unlikely. But it does just say, look, folks, be mindful of who you're voting for, be mindful of what they're enacting at the time, and stay out of the courts. I tell my clients then, I told folks who appeared in front of me back then, the best way to deal with the legal system is to stay out of it in the first place.
Absolutely. And just I want for the people online who are always asking these questions, well, I'm not going to vote because I don't like Biden. I'm not going to vote for this and the other reason. There's still these state and local issues that are so crucial. So even if you don't want to vote on national issues, you have to remember that if you want to change laws like this in a state like Ohio, you're going to have to register. You're going to have to vote. You're going to turn other people out. We have the numbers. We just need the people motivated and registered.
That's right. What do we say all the time? All politics is local. We may be excited about presidential elections. We may be excited about governor's races, but all politics is local. It's the local elections that ultimately decide our direction and impact us the most. And this is the perfect example of that fact.
Rebecca.
I want to ask so many questions, but I won't for the sake of time. I'm going to forget my due process question that I have, because I don't even see how this is remotely constitutional and how this is not a violation of due process. But that aside, I'm going to suspend my disbelief right now. Let's assume that the prison system in Ohio is saying that it is their job to rehabilitate those who enter into their penal system. So just to make sure that I'm understanding and viewers watching also understand. So if someone is showing bad behavior, i.e. showing that they're not rehabilitated, how is it their fault that they're not rehabilitated? Wouldn't that actually be on the prison system in Ohio? And wouldn't it be the prison system's fault that rehabilitation hasn't happened?
Well, that's an interesting point. What is the title of the entity that's over this? It's the Department of Rehabilitation and Correction. It's the Department of Rehabilitation and Correction, which says in its name that its primary concern should be the rehabilitation and the correction of those individuals who have to come through those doors. And that's correct. If they're not rehabilitated, there's an entity to blame for that, and that would most likely be the Ohio Department of Rehabilitation and Correction for not ensuring that those who pass through those doors are different than when they come in. Laws like this, rules like this, make it less of a responsibility for those departments to act consistent with their mission and their stated purposes.
So with a quick follow-up then, if it's now the role of the rehabilitation department to rehabilitate, and if they're saying by their own admission that people aren't being rehabilitated, then technically couldn't prisoners sue like under a property claim that they're not getting what they're told that they're supposed to be getting during their experience in prison?
I imagine that they could, and I'm guessing that there probably have been similar cases, but as someone who practices constitutional law and civil rights law, I can tell you that there is a presumption that there are fewer and less enforceable rights that prisoners have than folks who are not incarcerated. So, for example, I do medical malpractice. In medical malpractice, you say that the standard of care that a person received fell below a certain threshold. In prison, that threshold is actually lower because they're allowed the minimum standard of care when it comes to medical treatment that they receive. So is that possible to have a lawsuit saying, look, you all said you're about rehabilitation. I'm not rehabilitated, so I'm going to, I'm entitled to compensation or even release early because you're not doing your job. Sure, that argument can be made, but I would argue that that would be an incredibly high hill to climb for an inmate to successfully argue that it's their responsibility and that they have a constitutional responsibility to ensure that that happens.